Welcome to an insider's look at strategic employment law mediation, take two. And I say that because this was originally presented live back on June 28, 2021. We recorded it so that those of you who wanted to watch it again or who couldn't tune in the first time would be able to enjoy it. And sadly, it was recorded without video. Since we knew everybody would want to see our faces, we've decided to regather again on August 9th, 2021, and re-record. For those of you who don't know me, my name is Stuart Rudner. I'm an employment lawyer with a practice focused on employment law, advising employers and employees on all matters relating to employment law. And a growing part of my practice relates to employment mediation, helping the parties to resolve employment disputes. I am one of your hosts today, and your other host is Mitchell Rose.
Hi, thanks, Stuart. I'm Mitchell Rose. I've been an employment lawyer for employers and employees for about 26 years. I currently have my own firm in Toronto, Mitchell Rose Law. I also am a mediator of employment disputes, primarily wrongful dismissal and human rights matters. And I operate under the name Rose Dispute Resolution. I'm Rose, and I've been doing that for about 14 years. I'm also an arbitrator, and currently, for a little while longer, the chair of the ADR section of the Ontario Bar Association.
Yeah, as long as we don't have to re-record this again, you'll still be the chair when this is finalized. So our topic today is how to win at, or sorry, it's a strategic look at employment law mediation, what I think of as how to win at mediation. And I've made that comment many times over the years, and I often get strange looks for it because we often think about mediation as being involving settling. And obviously the goal of mediation is to resolve the dispute. But as counsel, your goal is to get the best possible result for your client. And one of the reasons that Mitch and I wanted to present this session today is because when we're acting as mediators, we often see counsel that are missing opportunities to advocate as effectively as they can on behalf of their clients. And many times it's because of an attitude of essentially it's just mediation and they're not preparing or advocating the way they would at trial. And it often, might result in a settlement, but it may not be the best settlement you can get for your client. So our goal today is really to talk about some of the things that we've observed and to provide some tips on how you can mediate as effectively as possible for your clients.
And just by way of some final housekeeping, I wanted to mention that this program has been accredited by the Law Society of Ontario for up to 45 minutes of professionalism content, and it is eligible for up to 15 minutes of substantive content. And so that's for you Ontario lawyers and paralegals who are watching. Stuart and I are both still practicing law, as we mentioned, and we like to think of it this way: we're in the trenches with you, you being employment counsel who are watching this. And so we see things really from both perspectives. We're not mediators talking on from high, down to counsel below. We're still attending and preparing for mediations. And so we're going to tell you what we think works and what doesn't work, taking into perspective both of our professions. I'll also be mentioning throughout the presentation some authorities, and you should have received, if you've ordered this presentation from us, you should have received a document as well listing the names and sites for the authorities. If for some reason you don't have that, then please contact either one of us and we will send that to you. Stuart?
Great, thanks, Mitch. And yeah, I just wanted to add, as Mitch said, we're both actively practicing, we're both in the trenches. But I remember my first time acting as a mediator, and you see the process from a completely different perspective. And you realize that as the mediator, you are effectively negotiating both sides of the case. We're going to talk a lot today about how you can make your mediator's job easier and essentially help them to help you. That's one of my mantras lately is help me to help you when I'm acting as the mediator. And part of it gets back to what I said earlier of really preparing as heavily as you would for a trial to make sure that you can put your best case forward. And not just treating it as just mediation. So we're going to come back and make a lot of, get into a lot of detail as to what works and what doesn't work. So I think you've covered the roadmap, so we can take it from there, Mitch.
Great. Yeah. Well, if you know me, you know I like maps. You can see that behind me anyway. So, yeah. So I'll give you the roadmap for this presentation. So the first section we're going to talk about are initial decisions, things like when to mediate and choosing your mediator. We'll then move on to strategic briefs. What should be included, how long should it be, what should not be included. We'll then talk about pre-mediation strategy, assessing the other side's your case, the other side's case, the potential for settlement, and of course, importantly, preparing your client. We'll then move on to the day of mediation. We'll cover things like who should participate, how to best work with your mediator, how open should you be with your mediator. We will then spend a little bit of time talking about managing client expectations, discussing how the case might settle, for example, things that you might not have thought of, different tricks that we've learned. We will then touch on breaking an impasse, a very important topic. We'll cover things like mediators' recommendations and baseball arbitration. And then we will finish up with minutes and releases on the assumption that you have settled your case. We want to make sure that you're doing everything necessary to paper the deal, so to speak, even if you're not actually using paper anymore.
All right, sounds good. So let's get, I guess let's get right into it and start with the
Get
initial
right
decisions.
into it. Right. So when to mediate, and so the first topic of initial decisions is when to mediate. So look, the first thing is, if you're an Ontario lawyer or paralegal, you're probably aware of mandatory mediation, where which applies under Rule 24.1 of the Rules of Civil Procedure. And right now, that applies to civil actions for the most part in Toronto, Ottawa, and Essex County, which includes Windsor. And so you might want to be strategic then about where you commence your action. But I was just speaking with someone today, Stuart, and a lot of people I find still think that if you decide to commence your action in a jurisdiction where there isn't currently mandatory mediation, that you don't have to, or there's no point bringing up the prospect of mediation with opposing counsel. And you really should, because it's likely that they'll be interested in a mediation, even if it's not mandatory. But I do find, and I'm sure you do as well, that Rule 24.1 does cause a lot of plaintiffs' counsel to forum shop. And so you see a lot of cases starting in Toronto that may have no connection to this jurisdiction because of mediation. So that's just something to consider, both starting an action, where mandatory mediation applies, but if it doesn't apply to the jurisdiction where you started the action, make sure you at least raise the issue once, twice, maybe 3 times with opposing counsel, because hey, they may agree. You should also make sure that you're paying attention to contractual provisions that may provide for mediation. Despite the Supreme Court of Canada's decision in Uber and Heller, arbitration clauses and mediation clauses, and often the arbitration clauses have a mediate first provision in them. They may still be applicable, and they may still be enforceable. It's difficult and challenging to enforce such an agreement, and you have to be mindful of things like unconscionability, of course, and the Employment Standards Act in Ontario. But there is a recent Ontario decision where an ADR clause, including mediation, was upheld. It was in an employment contract, and it was upheld, and the court stayed the action in favor of arbitration. And that decision is Leon and Dealnet Capital Corp. 2021 ONSC 3636. It's a decision of a master, and it may be under appeal, so we'll see what happens with that. Other considerations, the rules of professional conduct in Ontario really, I'd say, strongly encourage lawyers and paralegals to mediate. It's 3.2-4 or -4 for lawyers, so the LSO rules of professional conduct, and the paralegal rule that's very similar is 3.02 sub 11 and sub 12. There are similar rules in other provinces. Basically, these rules talk about encouraging compromise and settlement, that lawyers and paralegals must consider the use of alternative dispute resolution, which of course includes mediation, when appropriate, and inform the client of the ADR options, and if so instructed, take steps to pursue those options. So ethically, it's a good idea to recommend mediation to your clients, even if your client doesn't instruct you to do so, and even if it's not mandatory because of a rule of civil procedure or a contract. And just to top it all off, there may be cost consequences after trial if you're the party that refused to mediate, even where mediation isn't mandatory. The authority for that is a 2018 Ontario decision, Canfield and Brockville, Ontario Speedway. The site is 2018 ONSC 3288. It is not an employment law decision, but I don't think that matters. It is definitely worth a read. In terms of timing, generally earlier the better. There are certain situations where mediating later, perhaps after examinations for discovery, may make sense. For example, cause cases, but not all cases. I've been involved in a lot of pre-litigation mediations or mediations that are held before the close of pleadings. The other thing that's important to note is that, there's no rule against having more than one mediation. And the second, the first one might be you give it a try, you get to understand the other side's position better, more about, why they're taking the position that they're taking, including settlement positions. But some more information needs to be exchanged, some more things need to happen. And so really, if you try to have a mediation again, it may also then at that point be ripe for settlement. And it doesn't even have to be a full half day mediations being very popular among the Ontario employment law bar, especially with having online mediations these days. Something can be booked probably pretty quickly, and it won't take a lot of time to have a second mediation. Last thing I'm going to say on this topic before turning it over to you, Stuart, is consider a private mediator for Human Rights Tribunal of Ontario cases, as well as small claims court, to avoid the current backlogs that are taking place. It may be worth the money to hire a private mediator, especially with cases that are larger in terms of monetary amounts involved. Stuart?
Yeah, thanks, Mitch. And not surprisingly, I agree with all the points you've made, including the idea that mediation, generally speaking, the earlier the better. With some exceptions, as you said, cause cases. I've spent way too much of my career studying just cause cases and writing a book and updating the book twice a year. So I see all the decisions, and I know that there are some that are factually complex enough, or that there are enough facts in dispute that you need to have discoveries first. But in most cases, you probably don't. So it's certainly worth raising the issue early, even before a claim has been filed in many cases. Or, as Mitch said, consider splitting your mediation. So have a mediation. You might be able to narrow down the issues, agree on some things. For example, agree on what the notice period might look like if there is no cause. Then go to your discoveries and focus really on the issues relating to cause, and then go back and see if you can resolve it at that point. So you can be creative, especially in the era of video mediations, where not everyone is trekking to one location and spending hours and hours on travel time. You can be creative. The other point I'll mention is just be creative in what you mediate. I've had some really neat mandates where I have mediated situations where it's not the traditional litigation or pre-litigation context we all think of when we contemplate mediation. It might be, for example, there's been harassment allegations and maybe there was an investigation. And now, of course, we've got to get the workplace back in order and have people working together one way or another. And I've been able to go in and mediate the relationships and get things back on track. So think about non-litigious disputes, but things where there are disputes or at least personality conflicts. And if you want to get everyone working together, mediation can be really effective in that context as well. So I think that's really all I wanted to add on that point.
Thanks, Stuart. So moving on to choosing your mediator, one thing that comes up a lot is, do you need a subject matter expert? Now, when it comes to employment law, I think you do need someone with expertise in employment law. I can't think of any exceptions. It doesn't mean that it needs to be somebody who only practices in that area, but they need to have a very strong working knowledge of employment law, in my opinion. But beyond that, I think the type of mediator that you need and the particular skills that they have and the strengths that they have really depends on the type of case, the issues, your particular client, what kind of mediator is going to work best with your client, who's your client going to relate to the most, who are you going to best relate to. So it's really important to know your mediator. Everyone has different styles and different approaches. Sometimes you need somebody, who might be highly evaluative. Sometimes you don't. And in fact, you want somebody with so-called soft skills. So I think it's important that you give a lot of thought to the mediators that you're going to propose to the other side. Everyone tends to throw out, 1 to 3 names usually. Give some thought to it. Try different people. Speak to your colleagues. It's also really important to consider diversity and inclusion. Try not to use the same mediators over and over again if you can avoid doing so. Stuart, what do you think?
Yeah, I mean, I agree. I think it's really critical to choose the right mediator, and it's going to depend on the case, the nature of the case, and also your client's goals in the case. So, as far as the nature of the case goes, if it's what I'll call a purely business transaction, where it's really a notice case determining how many months, what a month is worth, maybe there's some other compensation, but no one really cares about discussing the facts or basically getting something off their chest or having their day in court, quote unquote. If that's not the goal, if the goal is just a business transaction, get this settled, you might want someone who's a bit more evaluative, might be a bit more gruff, might be a bit more to the point. That might be great for that kind of case. If you have a case where it's there are issues along the lines of sexual harassment, if you have a plaintiff who has been undergoing counseling for anxiety and distress, you're going to want someone with those soft skills that Mitch mentioned that will take the time. And as well, if you have a client who needs to have their day in court, even though it's mediation, you're going to want to have a mediator who will let them talk, let them vent, and then bring the process around to talking about how the matter can be settled. So it's not one size fits all by any means, and it's important to talk to your colleagues and find out, if you don't already know, find out who would be good in that context. And I also mentioned it's important to understand your client's goals. I know, Mitch, you said a minute ago you couldn't imagine the context where a subject matter expert wouldn't be appropriate. The only context I can think of is where your client doesn't want to settle. Right? If there's mandatory mediation and you're just going to go through the process, but your client has no desire and no inclination to settle, then you can just get a roster mediator and not worry about their knowledge and their background. Other than that, I can't think of a scenario where it doesn't make sense to have a subject matter expert in the employment law world and then look for the right personality for the job. And speaking of personality, I mentioned some mediators can be gruff. Sometimes you want that. Sometimes you have a client who is not following your advice and needs someone to talk some sense into them. Sometimes it's the other side who needs someone to talk some sense into them. But think about it, and I say this somewhat facetiously, but think about how your client will respond to being called an idiot, because there are some mediators that will, and sometimes that can be really helpful, but sometimes it will not go over well. So you need to consider the personality of your mediator in addition to their expertise.
Yeah, those are excellent points. The other thing to consider is how well will your client, though, or will you respond to a mediator who isn't tenacious and who packs it in as soon as you reach an impasse? The one thing I always look for in a mediator is tenacity, but knowing also when to turn it off. So tenacious, but not obnoxiously so. But no, tenacity is very important. But to go back to your point, though, Stuart, about the client who doesn't want to settle, the thing is, though, they may say they don't want to settle, but if you have the right mediator, they might settle. So it is a consideration, though. I mean, sometimes, having a non-subject matter expert in a certain case could be appropriate. And by roster mediator, we mean someone who charges tariff in Ontario. If you're watching from outside Ontario, someone who charges tariff, so basically a lower amount, lower than Stuart and me, but do consider the fact, though, that clients do come around. Mediation is a process, and so you want to make sure you still have the right person doing the job. I'm going to turn to the mode of mediation, the format. And so one thing that's come up a lot lately is people are saying, well, are asking, when will in-person mediations return and when? Because, here in Southern Ontario, we haven't been doing in-person mediations for the most part, since March of 2020. And and there's endless debates about whether Zoom's going to be the new default. It used to be that in person was the default mode of mediation, and video conference was the exception. My sense is, and I'm just making a prediction, is that probably video conference mediations will be the new default, and there will be situations though where some people will want to have it in person if it's safe and effective to do so. Hybrid mediations are something that I think we should look out for, particularly, to some extent in 2021, but perhaps more so in 2022. Hybrid mediation is where it's part in person and part by way of video conference or telephone, I guess. I did have some experience with that last summer, where to accommodate someone's disability, somebody wasn't able, due to an injury, to spend much time in front of a computer, and so they and their counsel attended in person. I attended as well. We were distanced, masked at a court reporter's office, and then the other side was communicating with us via video conference in a physical breakout room, and I was walking back and forth, just like in the old days, down the hall. And I thought that was quite effective, and it works. And I think it can really be appropriate in certain situations, particularly where one side really needs to be in person and can be in person, but the other side either doesn't want to or can't, or there are geographical limitations. So you have a client who's out of town, for example. Something to bear in mind is, in Ontario, there's a relatively new rule of civil procedure 1.08 sub 8. It was actually recently updated. It came into effect in January of 2021, but it was recently updated in August of this month, or actually July, but and will take effect in, it's all summer to me. It'll take effect in September. And basically, it provides a format for resolving disputes between counsel with respect to the method of attendance. And so I think in the future, we may see an increased number of disputes over attendance. But for now, it seems that Zoom mediations are going to be with us for the foreseeable future. And I haven't had an in-person mediation in quite some time, or even a hybrid mediation in quite some time.
Yeah, I mean, I would agree. And I have to say, there were a lot of skeptics at the beginning about, how effective video mediation could be. And people would say you can't read body language and you can't connect as well. And I have to say, I disagree. I mean, I think when you're talking about a trial or a hearing, there are other concerns. But for mediation, I have found it to be tremendously effective. And my settlement rate, which I'm proud to say was quite good to begin with, has been even higher over the past year. And there's a few reasons for that. I mean, one is just the convenience and the comfort. First of all, we're not forcing everyone to travel, often to downtown Toronto or wherever the case may be. People don't have to spend the time and the money to travel, which makes it a lot easier, and they don't have the same time restrictions. So it used to be that someone might have to leave at 4:30 to get home and prepare dinner for their kids or whatever the case may be. Now they can be at home, we can break for an hour and resume. As well, there's a comfort level, and I've told this story many times, where I had a mediation several months ago now, where the plaintiff resided, a couple of hours outside of Toronto. And in the old days, we probably would have dragged her down to Toronto, so we would have made her either drive and then pay a fortune for parking, or take the train in. It would have been a hassle to get there. She would have been at King and Bay, which was not her world. She was not a particularly sophisticated plaintiff. She would have been uncomfortable from the beginning. And then we would have gone through the whole process and talking about things that were already quite uncomfortable for her. And it may have settled, but it may not have. In this case, though, because we did it by video, she didn't have to leave her house. She was sitting in her living room on her couch. She had her dog at her feet. And you could see where every time I would bring a proposal in, and she would start to get a little stressed, and then she would pet the dog and she would calm down, and then we could talk it through. And we got to an agreement, I think, largely because of the comfort level she experienced. So that was one huge benefit. The other huge benefit, I know we're going to talk about who you should have in mediation, but this is a big factor. A lot of times, if there's a corporate headquarters that is in another city or province or country, often if you have a U.S. based client or company, for example, you're not going to get in-house counsel to fly to Toronto for a relatively small or medium-sized wrongful dismissal claim. So what happens is you go through mediation, and the ultimate decision maker is not part of the process. And then you call them at the end, and because they weren't part of the discussions, it's often quite difficult to explain to them why whatever you're proposing makes sense. However, it's a lot easier for them to log in using Zoom or whichever platform you choose and be part of the entire process. And that can be extremely effective as well. So those are some of the benefits. One thing I was going to add just on the issue of masking, a lot of people want to be in person, which can be great. But it's also quite hard to read facial expression when someone's got a mask on. So as a mediator, I actually find it easier to read their body language and facial expression on video than I can in person when they're wearing a mask. And of course, be mindful of people with hearing impairments, where if they can't see somebody's lips moving, they're going to have a real problem hearing, or not hearing, but understanding what's going on. So something else to keep in mind as you assess what the best mode of mediation is going to be. But as Mitch said, I think video might become the default, but it will depend on the facts of each case.
Yeah, I mean, one thing I've noticed, and I think counsel should take note of, and just to follow up on your point about how it's harder to read facial expressions when you're masked. But if everyone's participating in a video conference mediation, so it's not a hybrid, but you are meeting with your client, let's suppose either at their offices in a boardroom together, or they're attending your offices in a boardroom, and it's usually because the client is let's say technologically challenged. One thing I really recommend, because during COVID you're probably going to be masked, and so it's hard to communicate, both you with your client and then the mediator with the two of you. Consider, if you have the space, putting your client in a separate room, setting them up with a laptop and the technology, and then they can be unmasked. You can be unmasked in your office or your boardroom, or however you want to set it up, but you're there together for when you need to be, but you're also apart for when you need to be, and that's really the best of both worlds. And I have noticed that when counsel does have the settlement rate go up. My settlement rate, though, in general, is higher with video conference mediations as compared to in person as well. A lot of mediators have also told us the same thing, so it's really interesting how that's come out.
Great. All right, so I think that's my cue to go to strategic briefs.
Strategic briefs.
Right, and I know we're also going to talk about preparation for mediation, and at least in my mind, these two things kind of blur together. So I will try not to repeat the same points, but I guess the biggest point I wanted to make, and I alluded to this at the outset, is there's a real difference between how counsel prepare for mediation and how they prepare for trial. And I think we all know this. When you have a trial coming up, I mean, you spend weeks and months, you leave no stone unturned. You interview every witness, you review every document, you prepare everything, and you craft everything, and you make sure everything is lined up as perfectly as it can be, so you can present your case as strongly as you possibly can. Whereas when it comes to mediation, many counsel take a pretty laissez-faire approach, and they may sort of copy and paste from their pleading, put it into a brief, maybe tweak it a little bit, and they show up at mediation with their client, and you kind of see how it goes. And it's often a nice social day with your client, whereas, which it can be, but you should also be very well prepared. And the reality is, even if you do that, odds are pretty good you're going to settle, but you may not get the best settlement you can for your client. I think it's important to put this into context. I mean, we know, and I've been saying this for as long as I've been practicing, because the stats I've always heard were that less than 2% of claims filed in Ontario actually get to trial. And I assume the stats are similar in other provinces. And I assume the number is probably lower now than it was when I started practicing 22 years ago. So the odds are you're not going to get to trial. The odds are that mediation is going to be your quote-unquote main event. And because most mediations result in a settlement, the odds are it's going to be the end of the litigation. So for all of those reasons, it's really important to put your best case forward at mediation and not hold back for trial. And all of that, of course, starts with the brief. because that is your very first opportunity to get the mediator on your side. And I think it's fair to say that, I'm sure, Mitch, you're the same as I am. I mean, I come into a mediation with an open mind, but I've read the briefs and I take the time to read the briefs and all the documents that you will submit. And so I have started to form some opinions as to what the issues are and where my questions are and what I'm going to focus on. So you want me to be focusing on the right things, and you don't want me to have a whole lot of lingering questions about your case. And I'll say it now and I'll say it again later, I'm sure. Help your mediator to help you. Remember that we are negotiating and we are putting your case forward in the other room, especially because, as is the norm, particularly in the employment law in Ontario, or at least in southwestern Ontario, we rarely have joint sessions anymore. Rarely do we have all the parties in one room. And even if we do, it's even more rare to have either side actually advocating or arguing their case. So odds are we're the ones who are going to be arguing your case. And you want to make it as simple for us as possible and spoon feed the information to me. Make it very clear what the real issues are, and don't just use the kitchen sink approach and throw everything in there. So I don't know if cause is a real issue, if mitigation is a real issue, because if it is, I want to know that it is. But if it's not, don't detract from the real issues. The other point I want to make, in addition to focusing on the real issues and making them clear and concise, is be creative. We are working in a very much an electronic world now, and your brief is not going to be submitted on a stack of paper. It's probably going to be a PDF, and you have the ability to use hyperlinks and embed videos and put anything else in there. So if it's a cause case and you have I'm taking this from something I saw a little while ago. If it's a cause case and you have a video of the person assaulting their supervisor because, of course, someone had their cell phone handy and saw that something was about to happen and started recording, if you've got the video, put it right there in the brief, and don't just say, well, we'll get the evidence if this thing doesn't settle, at mediation. Put it right there in the brief. So when I'm reading the brief and I read, so and so assaulted his supervisor, I can then watch the video clip, or I can see, if you have sworn statements, whatever it is, make the links and make it really easy for me to follow. And if you're going to make allegations, back them up. So again, putting in the video, putting in the documents, putting in witness statements if you have them. I think all those things are really, really key. And the other point I was going to make is, make it easy for your mediator to get to the key points. I love an executive summary. If you want to put that right at the front, and we all, if we're practicing in the employment law area, we all know what those details are going to be that matter in every dismissal case. So we want to put it right up front of a chart. How old was this person? How long did they work for the employer? What was their title? What was their compensation? Did they mitigate? What was the date of termination? What was the date of mitigation? Put all those things right up front so I don't have to hunt for them, and make it really easy. I had someone do this about a month ago and loved it. They give me a chart of the individual's compensation broken down by year, by month, by week, by day. We had all the numbers there. It was really easy to do the calculations as we went through the day. So make it really simple, and I'll just conclude by saying just spoon feed your mediator and make it clear what they should focus on. And if there's something that you don't really believe is a real argument, don't put it in. Or if you have a client who is insisting that you put it in, then talk to your mediator. We're going to talk about this later as well. You can have pre-mediation discussions with your client. I'm always very happy to talk to counsel before mediation so I can understand what the real issues are. So if you need to put something in the brief, but you don't want the mediator to get sidetracked down that particular rabbit hole, then just give us a call and tell us so we don't waste time on that point. I think that was all I wanted to cover. Mitch, I think you had a few things you wanted to add as well.
Yeah, just a few things. I mean, I think both of us agree that, we like this Goldilocks approach to mediation briefs, not too long, not too short. My own preference is 10 pages, double spaced for a statement of issues, or in other places you would just call that, a summary of facts, law, issues, whatever it's called, where you practice. That should be no longer than 10 pages, double space. Include just the key documents only. If you want to highlight key sections of the documents, that can be really helpful, both to you and also to the mediator. Hyperlinks for the cases that you're referring to, and really just include the most important case law. I don't think in a notice case you need to refer to Bardol, but I guess that's up to you, but I don't recommend it. hopefully your mediator knows about that case. You want to, if you're a plaintiff's counsel, you want to make sure you include a pretty a fulsome mitigation section, have a summary from Service Canada of any EI collected, so you're not scrambling for it in case it's needed on the day of the mediation. A history of settlement offers, if any, to date, including whether they're open or not, is really, really helpful. The other thing is, maybe just let the opposing counsel know, why hasn't the case settled yet, and what do you think that the mediator can do to help? And a little bit later, but you can also always speak to the mediator, or ask the mediator if you can speak to them confidentially before the mediation, if appropriate. So if there's something you don't want to put in your brief, you don't want the other side to see, you really think it's important for the mediator to know about, ask the mediator if you can speak to them confidentially. Most mediators will agree that it's not great. So it's, the rules are different. If you want to do more than what Stuart and I are suggesting, consider not sending the mediator everything, though. You might want to make a longer brief for opposing counsel and your client. Then, so 2 briefs are okay, as long as it doesn't create a huge amount of work for you. Most people do that, which is why it's just important to keep your brief short. But you're trying to educate the mediator. Always remember educating them. You're not trying to persuade the mediator or bombard them. The mediator make a decision, binding on an arbitrator. And you want to ensure that the mediator has read everything, and that you're not going to be charged extra for it if you send them an extra long brief. So I think it's just important to be concise. After all, it's called a brief. Stuart, we're going to move on, I think, to pre-mediation strategy now. What can you tell us about that?
Yeah, so a lot of it sort of relates to the stuff we've just discussed in terms of the brief. But I think what I really want to talk about here is the importance of having a candid and realistic discussion with your client before the mediation. First of all, meet your client. It is still shocking to me how often, especially when we were doing this in person, where the client and counsel would show up and it's very clear they've never really met before. So you want to meet. I mean, ideally it's in person or at least by video. It could be by phone if need be. But the more important point is assess the case. Don't just tell your client what they want to hear. Don't just, go through the other side's brief, but don't just go through it and mock it. Go through it and actually point out where there are strengths, where there are weaknesses, and then look at your case. For example, if you're on for the plaintiff and they are alleging that it was a toxic work environment, and they say, everybody there will attest to the fact that, this manager was abusive and a bully, etc. Well, you need to cross-examine your client and be a little bit tougher there and say, well, let's realistically look at this. So all the people that saw this, are they all still employed there? Because if so, they may not want to be involved and they may not want to risk your job. So can you actually get the witnesses that your client thinks they can? And conversely, what do the documents show? Because this is something that I say to all of my clients, and I say to almost everybody in mediation as well. Cases are not won based upon truth. They're won based upon the evidence. So even if they are alleging, again, I'll use a toxic work environment example, if they're alleging that they were bullied, if there are no witnesses that will come forward and there are no documents, then it's going to be, I'll say, an uphill battle. And it's certainly not an open and shut case. There are very few open and shut cases, but that's certainly not one of them. So realistically assess what the evidence will show. And I was going to say, don't create an unrealistic bottom line. In fact, don't create a bottom line at all at the pre-mediation meeting with your client. Because if your client comes in, let's assume you're on for the defense, saying we're not going to pay anything more than $40,000. If they come in with that mindset and then you go to mediation, first of all, you're missing a real opportunity here. Because as we said before, this mediation is likely the first time that your case is going to be assessed by a neutral third party. And if you've hired a subject matter expert, as we've strongly recommended, you want to get their opinion. And I know that I will offer my opinions on the case and the strengths and the weaknesses of both sides, what's likely to happen, both in terms of potential results, but also just time and cost involved. So you want to hear that, and you want your client to hear that. And then you can say, okay, well, realistically, based upon that, here's where this case should settle. And you probably don't want a bottom line, but you want to at least have a range that you're expecting. But that should really be developed once you've heard from your mediator. Otherwise, if your client comes in with their mind closed, you're probably not going to get anywhere in terms of getting things settled. Well, I think you've already said this, Mitch. I mean, look at some of the what I'll call the smaller items, but they can become big items, such as is there an employment insurance repayment obligation, or are there things like non-monetary terms that are important to your client, like references or an apology or training or anything else? If that's what your client is driving for, then you should know that, and your mediator should know that as well. So talk to your mediator after talking to your client. But I think the most important thing here is realistically assess your case and don't let your client come in with a firm idea of their bottom line before you've even heard the mediator's views of the case. I think that's all I wanted to say on that point.
Yeah, great. All really great points. Um, you know, one of the things that I think we both like, I like it as a mediator and as my practice and as a lawyer, is a pre-mediation call with the mediator. Most mediators, in my experience, do that with both counsel participating at the same time, brief calls, but you accomplish a lot, and it really sets up on the day of. Usually I talk about, as a mediator, I talk about, well, I just want to make sure everyone's on the same page about when and how. I used to say where, but where is not really relevant much anymore. But we talk about things like are there disclosure issues, and what are the issues in the case, and who's attending and who shouldn't be attending, and things like that. So that will really help. It's really part of the pre-mediation process. If your mediator doesn't offer that, ask them if they will conduct a pre-mediation call. More and more mediators are doing it. There's a good reason for it. But if your mediator doesn't do it, well, they probably should be doing it. And you can always ask them, because you'll find that it's time well spent, and it's really usually very little time. I've already talked about talking to the client, to the mediator, confidentially before the mediation if the mediator is agreeable. And I just want to say, some of the times when it might be useful to do that is if you have a client, for example, who just won't listen to you, or you got a client who really needs to settle, or there's some other issue that you don't want the other side to know about. Telling the mediator ahead of time confidentially can be really helpful, because you're giving them a heads up of what to expect, and they can prepare accordingly. I'm going to move on now to the topic of managing client expectations. I don't want to repeat what you made some really great points. A couple of things I'm just going to mention. One of the things I like to do as a lawyer, I'll do it as a mediator, but it's really great if lawyers do this with their clients ahead of time, is do a litigation risk analysis in writing with the clients, assign probabilities of success to each of the main issues on which your client needs to succeed in order to win. And then multiply those probabilities to see the likelihood of success. It can be a really sobering exercise. You only need about 2 or 3 issues for it to be useful. You don't have to go through every single issue. Otherwise, your client will probably end up with a 5% chance of success. But it's something worth doing. We could do an entire presentation on litigation risk analysis. So we're not going to talk about that beyond this, but it is something worth doing. There's a lot of material available online about that, though, and it's worth checking out. And you can later share your litigation risk analysis privately with the mediator if you wish. Just don't share it with the other side. One thing that I think is really important is making sure that the client understands all of the steps in litigation and the cost, risk, and time involved in each of those steps. You really want to have an educated client who understands the process and isn't left in the dark. Don't just make assumptions about what they know. So prepare that ahead of time, but before the mediation, make sure they're prepared. I mean, really, you should be talking about these things from the get-go when they retain you, or prior to that even, but make sure you discuss it prior to the mediation. Talk to them also about the concept of the costs of winning, not the cost of losing. That's important too. But winning isn't everything it's cracked up to be. So for example, you might end up, if you win a trial, you're going to end up with a public decision that's telling the whole world your story. Does your client really want that publicity? whether they're the employee or the employer. Focus also on what goes into the client's pocket at the end of the day, if they're a plaintiff, or what it's, what it's costing an employer client, instead of getting fixated on things like the number of months or things like extraordinary damages or costs. Make sure that your client is always focused on the bottom line, and ensure that you're confirming everything you talk about, the most important things you talk about pre-mediation. Confirm it in writing, get it in writing, do a little pre-mediation report to your client. Stuart, anything you want to add?
Yeah, thanks, Mitch. I'm a couple of points, and one of these, ideally you're not going to be discussing for the first time shortly before mediation, but consider things like med-arb or med-arb, depending on how you pronounce it, where you've got a combination of mediation and arbitration. If you have a client who either really wants this thing to be resolved one way or another, or a client who doesn't want this to be a public record, as you mentioned before, or if it's just a case where you don't want to use the regular civil justice system, because as we all know, it can often be very time consuming and inefficient, and you often end up with a judge who is not a subject matter expert. So there's a lot of good reasons to use arbitration in the employment law context. And I'm a big believer of doing that, because you can create your own process and customize it to the nature of the dispute. You can pick your judge. You can keep it confidential. So a lot of great reasons for that. So you can also combine it with mediation. So you try to settle, but if it can't be resolved, then you go to arbitration. We're going to talk about med-arb and baseball arbitration or final offer selection later. My point is, discuss these things with your client before the mediation, and then, as we've said repeatedly, it's ideal if you talk to your mediator before the hearing, but also during the hearing. I've had a lot of counsel over the last year and a half lament the fact that they've lost out on those hallway meetings with the mediator, where you used to be able to kind of intercept your mediator and pull them into another room and have those those discussions. You can do that in Zoom very, very easily. It's easy to create another breakout room. I will always give counsel my phone number so they can message me, they can text me, they can call me, and just say, hey, I want to either talk to you alone, or I want to get in a room with you and opposing counsel. Whatever the case may be, you can definitely do that, and it can often be very, very helpful. And I will do that. I'm always happy to discuss things before the mediation or during mediation, especially if there's what I'll think of as a politically sensitive issue. I never want to embarrass counsel in front of their client. So I'll give you the probably the example that comes to mind most frequently. If you're on for the defending employer and you're relying upon a termination clause, and my view is that the termination clause is not enforceable, I don't want to say this clause is unenforceable if I don't know whether you drafted it or not. So I'd much rather hear from you first and have you either tell me that you did draft it, in which case we can try to find a way to stick handle around that, or you can say, no, don't worry, it was somebody else, in which case I can be a lot more direct in what I say. But again, it's just, a big part of this is just talking to your mediator either before or at mediation, which I guess is probably a good segue to our next topic, which is the day of mediation. So I'll turn it back to you.
Thanks. And before we go into that, if you do wish to take a break, Stuart and I decided that this would be a good time. So, so feel free to pause and take that break. Okay, so let's assume that you either didn't need a break or you took a break and you're back. So welcome to the day of mediation. So I'm going to talk first about joint sessions, sometimes called plenary sessions. Look, in Southern Ontario, they haven't been popular in employment cases in at least the last 20 years or so. Back when I first started practicing in the 90s, they were really common in employment cases. They're still common in a lot of different kinds of disputes, but somewhere along the line, employment lawyers stopped doing them for the most part. Stuart and I, when we're the mediator, we don't impose them on anyone. Any counsel, we leave it to counsel to choose whether they want that process or not. But for the most part, we're doing caucus-only mediations, which is, I'm sure, what most people watching this are used to. But occasionally, as a mediator, I'm surprised when there's a lawyer on the other side, one side, who decides they want an opening statement. They want a joint session and they want an opening statement. And by the way, joint sessions don't have to have opening statements. Joint sessions can just be everyone's together in a room, a virtual room, or not in person. And the mediator is going to do all the talking and just explain their role in the process and things like that, and just saves a lot of time. So that's a possibility. But let's suppose you have someone who wants a joint session with opening statement. You know, I've been in a situation a lot of times where I've had to mediate that issue ahead of time. That's why I like to discuss it on a pre-mediation call, just to make sure everyone's on the same page about it. But look, you know, I think if you ever you have a mediator who requires you to do one, or you've got opposing counsel who insists on one and it's not worth the fight, or maybe they want to have an opening statement, doesn't mean you have to make one, then I think, you know, it's worth knowing how to do one quickly and efficiently and effectively. So it's just something to keep in mind and keep in your back pocket, so to speak, for later. If you're going to do one, then really it should be quick. Get in, get out is what I like to say. Don't get personal. Don't just rehash your brief. Speak to the decision maker, who's not the lawyer, who's not the mediator. You know, try to speak to the actual party. Thank them for attending. Say something nice. And really what you're trying to do is you're trying to convince them to settle for something closer to your client's best case than theirs. Don't make any threats. You catch more bees with honey. And, you know, you don't really have to say a lot. One thing, though, to bear in mind, and this applies not only to joint sessions, but it applies to anything that, any kind of mediation communication, what you say in your brief, what you might say on a pre-mediation call, what you might say during a meeting, during a Zoom mediation. You might have just a lawyer meeting with the mediator, as Stuart was referring to. The rules of professional conduct of your province, and certainly in Ontario, apply to mediations. So you always have to be on your best behavior. Otherwise, you could be disciplined by your provincial law society. So there is authority in Ontario for that proposition. It's Law Society of Upper Canada, as it was then known, and Geest, 2011 ONLSHP 24. I'm not going to get into the facts of that case, but it is certainly worth reading if you're a lawyer who participates in mediations. On this topic, I think it's also important that you insist that the mediator use a mediation agreement for better confidentiality protection. If they don't already use one, I use one, Stuart uses one. There's no reason you can't supply your own if the mediator doesn't use one. And you want to make sure that everyone participating in the mediation has signed it before the mediation really begins in earnest. Another thing, it's just a really technical point, is you do want to ensure that the mediation agreement that you sign provides for the parties to contract out of an exception to settlement privilege. This has to do with a Supreme Court of Canada decision from 2014 called Union Carbide and Bombardier. It's 2014 SCC 35. Basically, there's an exception to the form of privilege that applies to mediations, where what's discussed at mediation stays at mediation. The court can't know about any mediation communications. There's an exception to that if one side later says that there was a settlement or what the settlement terms were, and the other side says there was no settlement or we disagree about what the terms were. Well, evidence from the mediation can be admissible for the purposes of proving the settlement unless you contract out of that exception to settlement privilege. So I don't want to get too overly technical with this, but it is important that this kind of provision be included in your mediation agreement if you want to keep everything that happens at mediation, including your briefs, away from the court's eyes. And so if you need a sample clause, you can just ask us for one. Just also remember, though, you can't contract out of the rules of professional conduct of your provincial law society. In terms of who will participate, that's an important thing to think about. I covered this during the pre-mediation meetings I referred to before, or calls. You want all decision makers at the table, real or virtual. Ensure that also those people sign a mediation agreement as well if they're non-parties, so people like spouses, partners. It's important that you have everyone who may have a role in decision making be part of the mediation process. Stuart referred to the situation with in-house counsel earlier, and so I think that that sort of follows on the heels of what he was talking about. In terms of working with your mediator, one thing that comes up is how open should you be with the mediator? Should you play your cards very, very close? I think you should at some point be prepared to convey what I call your confidential optimal range of settlement to the mediator, not too early in the process, but not too late. And by that, I don't mean your bottom line. You don't always know your bottom line. It shifts with time. Stuart, referred to the fact that, you should have a bottom line going into the mediation anyway, but some sort of like optimal range. But be flexible about it, because if the mediator knows that and can keep it confidential, then the mediator really will be able to help you better than if they know nothing about that, or you only let them in on the secret near the end. A lot of times they can just move the goalpost, so to speak, so that you're not negotiating really, really far apart. Knowing everyone's optimal range of settlement, the mediator can suggest that you start from, here as opposed to here, so to speak. Okay. So consider that. It does require some trust, but you should trust your mediator if you've hired them. If you're making offers, don't start too high or too low, or you're probably in for a really long day or a very short and unsuccessful day. The opening offer can be an offer that you put in your mediation brief. I've seen a lot of people do that. They make a brand new offer to settle that no one's seen before in the mediation brief. Great, that can be your opening offer. But your opening offer at a mediation shouldn't be your best case, or just something that repeats your demand letter or your statement of claim or your defense, because otherwise, again, you're going to be in for a really long day. You need to show some movement, and you should do it right off the bat. Show that you're prepared to make some concessions. It shouldn't be your best offer. Your opening offer shouldn't be your best offer, but it also shouldn't be your best case. And always consider how the other side will perceive and respond to your offer. It's not all about you. In fact, it's really not about you. You're making an offer to the other side. You need to know ahead of time and to consider how they may react to it. Don't be scared to make a first offer. If you're asked to negotiate against yourself, so to speak, that's okay. Because of anchoring, something called the anchoring bias or anchoring, there's been studies shown, it's not a scientific law, there's studies shown that have shown that if you make the first offer, then the settlement will likely be closer to your first offer than if you didn't make the first offer. But so bearing that in mind, there's a lot of control in making the first offer. Personally, my favorite approach when I'm the lawyer at a mediation is I like to make a first, a second, a best, and then an absolute final offer if I need to. So 3 offers at least, 4 if necessary. Sometimes I map them out ahead of time, but you don't know exactly what you're going to get back from the other side. So you can create a script, but be prepared to depart from your script. Something that's really important is don't say final unless you really mean it. And even if you say final, then be prepared to hear information you don't want to hear, because you never know. So if you make a final offer and the other side, the mediator comes back with something, a final offer from the other side that's different, don't tell the mediator, I don't want to hear about it. I already made my final offer. Well, no, you should hear about it and consider it. Maybe you're not going to change your minds, but at least hear out the mediator. Final thing I'm going to say on this point is make sure you take your own notes, very detailed notes, during the course of the mediation, or have somebody who's participating with you, another lawyer from your office or a student, or both of you, take very detailed notes about everything the mediator said during the course of the mediation day, what your client said, not just listing the offers. That's very important too, but it also includes advice. Maybe your client told you about a bottom line, put that in there, advice that you gave your client. You can't rely on the mediator's notes. First of all, they might not be as detailed as your notes. They don't really need to be. And you have no right to the mediator's notes usually under the mediation agreement, but also under the common law. It's very difficult to compel mediator's notes to be disclosed. But your notes, your own notes, could save you later if there's a misunderstanding later about what the settlement was, or what you recommended, or what the mediator recommended, or if your client decides to assess your bill. Your mediation notes will really come in handy. Stuart?
Yeah, thanks, Mitch. That was a lot of really good points about the day of mediation. So I'll just add a couple of things. I mean, first of all, I've developed a practice over the last, I guess, year or so, where assuming that the briefs are in sufficiently early that I can properly review them a couple of days before the mediation, and assuming we're not going to have a plenary session, I'll try to let you know who I'm going to start with. So I can say, I'm going to start with plaintiff and their counsel at 10 or even at 9:30. And so I know a point that Mitch, you often make. There is no rule anywhere that says mediations always have to start at 10 o'clock. We just always default to court times, but
it's alternative dispute resolution. So
exactly.
Why start when the court starts?
Exactly. We can take any alternative we like. So I'm happy to start earlier. And as I said, if I know, if I've had a chance to review the brief, so I think, it's going to be most effective for me to meet with the plaintiff first. And I can tell everyone, I'm going to meet with the plaintiff and their counsel at 9:30. And so defense, you don't need to be ready before like 10-ish or so. So I will try to let you know as long as I get the briefs sufficiently advanced. If you get them to me the night before, I won't have a chance to do that until the morning out probably. But that was one point. Also, let your mediator know about any timing or availability issues. If someone has a hard stop at 2 p.m., it's really helpful to know that sooner rather than later, so I can try to work towards that. Or if it's a matter of someone needs to be offline between 3 and 4, we can work around that as well. But talk to your mediator. And then on your point, Mitch, you talked about how open should you be. I mean, it really is helpful to be open, especially if you have a mediator who is not what I think of as a glorified career, who's just going to take offers back and forth without really adding any value. And I know that I will not, I'll certainly take offers back and forth, but I'm also listening, and I'm also trying to get a sense of what your goals are, how far you're willing to move to get a deal done. And as we go through the process, and hopefully as you're being more and more open with me as that trust develops, if we didn't already start with it, I will have a sense of where there is some room for overlap between the two parties, or if it doesn't exist, how I might be able to create that overlap. And at some point, I'm probably going to start suggesting offers to you with a goal in mind that I think will get this case settled. So I will not just take your offer and take it to the other room. Ultimately, if you instruct me to, I will. But I will give you feedback. And if I get an offer and you say, go in the other room and offer $60,000, I will tell you that, if I do that, the odds are what's going to happen is they are either going to physically or virtually walk out. And that's going to be the end of the day. So here's, if you tell me that you want to end up here, here's where I suggest that you start. And then we can try to move towards that point. So work with your mediator. Again, allow us to strategize and try to figure out how to get to your ideal range of settlement, as you put it, Mitch, as opposed to a bottom line. So I just want to talk about that. And then the last point I wanted to make really is, have the evidence available. So I said before, if you're going to make a point or an allegation, back it up. But you're probably not going to bring your whole file, whether it's physically dragging some boxes down to a reporter's office or just getting on Zoom. Make sure you have everything available electronically. So if an issue comes up that you didn't expect to be an issue, rather than saying, "Oh, I'll have to find that," and then kind of leaving things with a question mark, you should be able to access all of your documents very quickly, especially in the days of electronic storage. So make sure you have everything ready, either immediately available with you or immediately accessible. That'll make things go a lot more smoothly on the day of mediation. So I think unless you had anything to add, I'll move on to breaking an impasse.
Oh, go ahead and move on, please.
Perfect. Thank you. So, and this sort of blends into my comments from the last section. You're going to want a mediator who is going to be flexible, strategic, and as Mitch, as you said before, tenacious. I don't think either of us likes, leaving without a settlement. Both of us will do whatever we can, which means not being a glorified courier, not being purely evaluative, but offering, there's no reason why your mediator can't offer some evaluative comments on the case, but also use some of those soft skills and some of those strategic skills, and try to figure out how to bridge the gap. And one thing that is often, I guess it's not amazing to me anymore, but I've gotten used to it. It's usually easier to bridge that $300,000 gap than it is to bridge that last $10,000 gap. And that's where your mediator often really earns their fee, is by helping you to get that settlement done. And sometimes it's purely psychological. Sometimes the impediment is that neither party wants to accept the other party's offer. They don't want to be seen as having settled for what the other party put forward. So, and I know, Mitch, you and I are similar in this way. We will try to be very creative. And one of the ways we do that is the mediator proposal. Because again, we've been going back and forth for probably several hours, and we've heard what you've said, and we've heard what you've said to each other, and we've heard the underlying messaging that's coming forward. We have a good sense of how this case might be able to settle. And so what we'll often do is we'll say, you know what, we're this far apart. We're between, I'll just pick numbers out of the air, $70,000 and $80,000. And we're not necessarily just going to split the difference, because you don't necessarily need a mediator to do that. But we might say, based upon all the discussions, it seems likely that $87,000 is going to do it. So that's what I, as a mediator, am proposing. And then there's a very clear process for doing this. It's a double-blind system, essentially, where we'll propose that in both rooms in the same way. And if both parties accept, then there's a deal. And if either neither party accepts or one does but the other doesn't, there is no deal. And in theory, if there's no deal, that's the end of the day. In practice, sometimes it does simulate some more discussion. So there is often a second kick at the can, so to speak. But that's one way that I have found that we can very successfully bridge that final gap. Other things that we've talked about already, some of them, things like med-arb. So if you have agreed, ideally beforehand, that if there isn't a settlement, then your mediator becomes an arbitrator. That's a way to do it. You can also agree on the fly. You just want to make sure to document it very carefully. Or, as Mitch mentioned earlier, baseball arbitration or final offer selection, which in a nutshell means that both parties put forward an offer, and your mediator, who's now put on their arbitrator hat, has to pick one. They cannot decide on any other form of resolution. They've got to pick one or the other, which of course forces both sides to be quite reasonable, because if they're not, they know that you're going to pick the other side's offer. So that's another way to bring about a settlement or a resolution, I guess I should say, at the end of the day. And if you have a client who is really keen on having this thing done and putting it behind them, that's another, I guess, strategic or flexible way to reach a finality. And I've said this before, but I'll just mention it really quickly again. Before you even get to mediation, consider whether you want to have an arbitration put in place or a med-arb agreement in place, so that either it can be all done in one day, which it can be done in some cases, or at least you have a plan so that instead of ending the mediation by saying, well, we didn't settle, so I guess we'll now go through the next year or two in litigation, you can say that we didn't settle, so we're going to go to arbitration in 3 weeks or 2 months or 3 months, but you have a firm timeline in place. That's often very helpful in getting a deal done. And I guess the last thing I'll say, I'm not sure if I've already said that, but I really mean it this time. The last thing I'll say is med-arb can actually work really well if you do the arbitration first. Now, there's some consequences of that, so you want to think about whether it makes sense. But in the right case, if you do the arbitration first of all, there's no concerns about your mediator hearing things they shouldn't have as an arbitrator. So it addresses that concern. But second of all, it can create a real pressure to settle, because if you have the arbitration first and the arbitrator writes down their verdict and puts it in a sealed envelope, and obviously I'm thinking about this being in person, but you can recreate it virtually, puts it in a sealed envelope, and it's sitting there on a desk, and both parties know that if they don't settle by the end of the day, that envelope's going to be open, and they're going to have a decision imposed upon them. It'll make them far more willing to work towards an agreed upon settlement where they can have some input, as opposed to having someone, as I said before, impose it upon them. So those are just some of the ways that you can be creative to break that impasse, which you will almost inevitably get to at some point during the day. Mitch?
Yeah, those are great points, and I would just follow it by saying, a lot of recommendations I do as a mediator often take place in the days following mediation. The parties may not be ready for a recommendation if they can't settle on the day of, but if I follow up with them, they might be interested in a recommendation, and I make the recommendation then at that time. Usually I make it in writing, and I ask that counsel, I make it to counsel, and counsel share it with their clients, and they have a certain amount of time to respond to me through using the double-blind method. So no one gets hurt, no one's bargaining power is lost by doing it. It's really amazing. I find that most recommendations I make end up in a settlement. Same thing with if you want to do final offer selection or baseball arbitration or med-arb, people can decide to do that after the mediation, after the dust has settled in the days or weeks following. I don't recommend, though, having the mediator turn arbitrator if the mediator's made a settlement recommendation already. I don't think those two really go together. I think it probably should be one or the other if you're asking the mediator who conducted your mediation to then be the decision maker. I'm following that. I'm just going to make a few other comments. Great. Listen, it's great to settle cases, but always remember that you should never bully a client or let a client be bullied into settling. And bully can simply mean just pressured. There's a recent decision out of Alberta called Rashura and Jones 2020 ABQ 139, which is a really great read about what all the things that can go wrong at mediation. It's a lawyer's negligence case in which the plaintiff was successful. Read it, and if you're ever in doubt that your client isn't absolutely sure, is hesitant about entering into a settlement, so let them sleep on it. Confirm everything in writing, of course. Let them sleep on it. Ask the mediator if they can ask the other side to keep their last offer open for a certain amount of time. Even if it's a matter of a day or two, that can really help. They may just need some time to let things percolate. The other thing is just to make sure that your fees, especially if you're acting for a plaintiff, make sure your fees are confirmed in writing with your client before settling. It should be in your notes, but you should also, email something to your client if you're participating in a virtual mediation, confirming what the fees are going to be, and make sure you're complying with if it's a contingency fee arrangement, make sure you're complying with the local rules of professional conduct and local legislation with respect to confirming fees in writing. I'm going to now assume that a settlement was entered into, so I'm going to talk about minutes of settlement or minutes and releases. They usually go together. So the first thing I want to say, and this never came up, or rarely came up in the days of in-person mediations, but I think it's easy to get I don't say lazy, but it's easy to get a little casual with virtual mediations. But really, minutes and releases should be prepared and signed on the mediation date. If you've reached a deal in principle, then it should be documented and signed right away. Take that extra time to do it. First of all, you should be coming to the mediation with draft minutes and releases ahead of time anyway, to the extent that you can prepare it, especially if you represent the employer. But even if you represent the employee, it's a good thing to do. And so you already have a head start. A lot of times you might just be plugging numbers and dates in, and or adding a few terms, deleting a few terms in your draft. Don't just rely on confirming things by email if it can be avoided. If it's absolutely necessary, it's really late, you've had a marathon mediation, it's 11 o'clock at night. Okay, that's different. Then maybe you're better off just having an understanding in principle. You're going to pick it up the next day and with the minutes and releases then. But other than that, I think it really should be done. And if you're going to leave things to the next day, make sure that you've at least confirmed client's instructions by email. And if you're going to confirm that there's a deal with the other side, actual settlement, and you're going to do it by email, then say something along the lines of, I confirm here's the settlement, but it's conditional on us entering into formal minutes of settlement and a release to follow on X date. Okay, and some things can be very helpful. Some things like DocuSign can be very helpful if you need to, electronically sign settlement documentation. Draft your documentation as though a judge may be reading it one day for purposes of a motion to enforce the settlement. So, it's very important. If in doubt about, whether you're leaving something out that should be included, phone a friend. Have someone to call, someone at your office or another colleague or friend who can help you, or ask the mediator what they think. It's not the mediator's job, though, to draft the minutes of settlement. Some mediators do think it's their job. I think they're in the minority, but really this is the party's deal, and counsel should be drafting the documents. The mediator definitely should be part of the process and reading the drafts and making sure it reflects what the mediator thinks the deal was, or the understanding was. And of course, the mediator should stay to the end to put out any fires that may start, because sometimes there are disagreements over the wording of settlement terms. It happens, and you need the mediator to mediate some of those disputes. So you want to keep them around. Again, in the in-person days, the mediator is going to stick around anyway, but it's when you're doing things by way of video conference, you just want to make sure that they're going to stick around, or that you can get them back on the Zoom call right away, or that you can all speak on the phone if need be. So that's really all I wanted to say about minutes and releases.
Yeah, I mean, I'm not going to repeat what you said. I think they were very important points. And I think we were all probably taught this as junior lawyers, that you never leave a mediation when there's a settlement without getting documents signed. That really is critical, unless, as you said, it's sort of the middle of the night. But otherwise, you absolutely should. And there's no excuse, just because you're doing it by video. DocuSign, HelloSign, any of those products make it ridiculously easy to get everyone to sign. Or you can go what I'll call old school and print it, sign it, scan it, or take a picture of it on your phone and send it back. If you have to do it that way, you can do it that way. But there's no reason not to. And as you said, Mitch, you don't want to let your mediator go and say, "Oh, we'll take it from here," because issues often do come up. So I will make sure that I am still part of the discussion, or I am at least immediately available. So if they need me, I can hop back on, in a moment's notice, and make sure that any hiccup along the road of getting things signed is dealt with. So I just wanted to add that, and also just in terms of you want to have ideally a draft set of minutes ready, and if you're the defendant, usually it's the defendant, bring it with you and have it ready to kind of plug and play as you go. But don't be stuck on templates and wording that you don't understand. If you want to put wording in there, make sure you know why, and don't be prepared to fight over it unless you really need it. And at the same time, though, I remember one mediation I did, where I was counsel, and we took about 5 or 6 hours to reach a deal, and then we took about another 5 or 6 hours to agree on the wording of the minutes of settlement, and it was just painful, and there was no reason for it, because none of the changes that counsel was recommending made any difference whatsoever. It was just his terminology he'd always used, and he didn't like mine. So, if there's a good reason for it, then absolutely advocate on your behalf of your client. But if not, then just make sure the minutes reflect what the agreement was, and then that should be the goal at the end of the day.
Yeah, you don't want to over lawyer.
That's a good way to put it. I like that. I think that was it. So I'll turn it back to you.
Thanks. So, at this point, we're really at the end of our presentation, or near the end. The original live performance back in the end of June, we then had breakout rooms where we gave people some discussion topics, and it was also possible for people to network. We had 3 separate breakout rooms. We would create them, randomly assign people, then break them up, create new ones. So if you are watching this in a group, or you want to discuss some of the following topics with some people, there's some things to think about. One of the topics was whether or not joint or plenary sessions are a good idea, with or without opening statements. What do you think about that? The other topic that was discussed during the breakout rooms, what do you look for in a mediator? You heard from Stuart and I about what we look for, but what do you think? And then finally, what do you think about breaking impasses? What works? What doesn't work? And you can also share your answers with us. We'd love to hear from you. And so feel free to give us your 2 cents on these issues or anything else that we've talked about during our presentation.
All right. Well, thanks for those comments, Mitch. And yeah, if you have any comments on those issues that Mitch raised, or anything else we've talked about, or anything else to do with mediation or ADR, then we'd be more than happy to discuss them with you. So feel free to reach out to us. My final thought will be that there's an old saying we've all heard, which is that the best way to achieve peace is to prepare for war. And it applies to litigation too. The best way to achieve a good settlement is to prepare for trial. In the context of this discussion, it means prepare for mediation the way you would prepare for trial. So just remember that mediation is advocacy, that you want to help your mediator help you get the best result for your client. So bear that in mind, and as I've said many times, spoon feed your mediator and make it easy for us to argue your side of the case and hopefully get you the best result you can for the client you're representing. That's really all I wanted to say. So other than, of course, thanking you, Mitch, for doing this and for a really enjoyable discussion, and thank you to everyone for tuning in. I would definitely love the chance to work with any of you, so feel free to reach out. And I know Mitch is going to be putting our contact information up on the screen momentarily. But that's all I wanted to say. So thanks again for tuning in.
Likewise, Stuart. It's great presenting with you and working with you. And yes, I look forward to working and hearing from people too. Working with and hearing from people. So here's our contact information, and thanks for tuning in.